Hello YouTube! While I was working on some super exciting link testing, I stumbled onto this fun document about our favorite Democrat president ever, and the first one to send us down this great modern trail of constantly getting impeached, or getting nearly impeached, or back and forth and back and forth. Anyway, my coworker next door is hopefully finding some relief from her sinus infection at urgent care. I don't know how long I have, but I figure this could be interesting, so I'll read it with you. And if you don't think it's interesting, and I don't think it's interesting at the end, then I guess it won't be. But hey, historical documentation is fun. So, without further ado, we shall get into this. So, that's the American Law Division of the Congressional Research Service, and this actually was one of their first or early online publications. And this is to explore a possible compromise between impeachment and taking no congressional action. Certain members of Congress and congressional commentators have suggested a congressional censure of the president to express Congress's disapproval of the president's conduct, which has been the subject of an ongoing independent counsel investigation. This report provides an overview and discussion of the legal basis and congressional precedents regarding a congressional censure of the president. And I may end up having to pause because I did not give myself water. Alright, so for those of you who weren't alive in the go-go 90s, it was a fun time, and we never really had to deal with this particular problem. Most presidents who lusted after other women kept it on the DL. You know, people knew about it, but it definitely didn't get blown up like this, and didn't end up getting blown up as like a pattern of behavior in Bill's case. So, there is no express constitutional provision which authorizes Congress to censure the president or any other executive branch official. A censure of the president does not appear to be, and has not traditionally been, a part of the impeachment process, which involves an impeachment of the House and a trial and a conviction in the Senate. A censure of the president is clearly not part of Congress's express authority to punish its own members, nor would it be in most cases within the inherent contempt powers of legislatures to protect the dignity, privileges, and proceedings of the institution and its members. Rather, a censure has been, and would most likely be, in the nature of a sense of Congress or a sense of the Senate or House, resolutions which have developed in congressional practice as vehicles to state opinions or facts in non-binding and non-legislative instruments. And that's key there. The House and the Senate have, on infrequent occasions, and mostly in the 19th century, aka the 1800s, for those of you who aren't historians, express their disapproval, reproof, or censure of executive officials, including the president, or certain of their actions in simple resolutions. Proceedings indicate that one action of the Senate, Andrew Jackson, 1834, though expunged in 1837, and two actions of the House, Tyler in 1842 and Buchanan in 1860, may be categorized in a broad definition of a congressional censure of a president. And I don't know my history well enough, so hopefully they'll get into that. Similar to a censure of the president, there's no express constitutional authority to fine the president or any other individual outside Congress, or to require anyone outside of Congress to make a monetary restitution. However, unlike a censure or other sense of the House or Senate resolution used to express an opinion, a mandatory fine legislated by Congress against a particular individual may run afoul of the bill attainder clause of the Constitution, as well as, if directed at the president, raise issues concerning the constitutional prohibition on diminishing the salary of the president, which in some presidents' cases is probably not going to make a difference. Anyway, also, unlike censure or other statement of disapproval formally expressed by the Congress, there have been found no precedents for the Congress to legislate or formally adopt a resolution expressly directing a specified individual who is not a member of Congress to pay a fine or a restitution to the government. Don't worry, we are still just on the summary. We'll get into the deets shortly. It may at least be theoretically possible for an agreement to be reached between the President and the Congress for the President to voluntarily accept a congressional statement, suggestion, and or direction concerning particular restitution or other act of contrition, and not to challenge the authority or constitutionality of any such legislative statement or act. In such a case, as a practical matter, it may be difficult for anyone other than the individual actually aggrieved or harmed, that is, the President, to possess the requisite legal standing to challenge in court such an arrangement on the basis of an alleged absence of of legislative authority or violation of constitutional precepts. And no, I do not quite understand what that means, but like I said, I'm sure they will get into deets. Such legal questions of authority, power, and standing aside, however, there may be implications for policy and precedent which the Congress may wish to consider and weigh in adopting a congressional response to alleged wrongdoing by an executive official, particularly the president, when such response is other than through impeachment and is not provided for in the Constitution. The joy of the Congressional Record Service is they're basically librarians hired to compile, what you need to know about a particular subject. That's why it's always fun to read like the security parts from CIA and stuff, because you're like, yep, those are librarians. So, getting into the nitty-gritty, let us continue on. All right. Exploring a possible compromise between impeachment and taking no congressional action, certain members of Congress and congressional commentators have suggested a congressional censure of the president to express the Congress's disapproval of the president's conduct, which has been the subject of an ongoing independent counsel investigation. This report provides an overview of the legal basis and congressional precedents regarding a congressional censure of the president. So here's some background. A censure is commonly defined in modern parlance to mean the formal resolution of a legislative, administrative, or other body reprimanding a person, normally one of its own members, for specified conduct. Now, the person thing could get interesting considering we now have corporate people. So in Congress, censures are most typically known as simple resolutions of the House or Senate formally adopted by a vote of that body and expressing some form of disapproval or other term of rebuke or condemnation concerning a member's conduct which bears generally on a breach of the rights and privileges of the institution. These censures of members are implemented under the express authority in the Constitution at Article 1, Section 5, Clause 2 for each House of Congress to punish one of its own members, which kind of makes sense. Elected officials can do bad things, and other elected officials may want to comment on that. Like, I don't know if we should necessarily be endorsing you. All right, a House, Senate, or congressional censure of the president, unlike a congressional punishment of one of its own members or an impeachment and trial of the president in the legislature, does not have an express constitutional basis. Although there is no express constitutional provision regarding censure of an executive officer, there is also no express constitutional impediment for the Congress or either House of Congress to adopt a resolution expressing its opinion, reproval, or disapprobation or censure of an individual in the government or of the conduct of the individual, and in fact, each House of Congress has on infrequent occasions adopted such resolutions in the past. Resolutions expressing the House or Senate's disapproval, censure, or reproof of an individual or of his or her conduct have on that occasion been adopted, for example, by the Senate, although later expunged, regarding President Jackson, 1834, and by the House in 1860 with regard to President Buchanan. Although not a resolution, a statement of very strong criticism finding abuse of power by President Tyler was issued by a select House committee in the form of a report, which was then formally adopted by the full House of Representatives in 1842. Simple or concurrent resolutions disapproving of conduct or censuring the president or other executive official, like similar sense of the Congress resolutions or sense of the House or Senate resolutions, would have no particular legal or constitutional consequence, but may have political and or historical import. So it doesn't really do anything, I think is what this is saying, other than like have some sort of like societal impact slash political impact. I don't want to say it's dongle waving, but it does kind of sound like it. And also this paragraph, yeah, you can quickly see the divide between people who are like strict constitutionalists who are like, it doesn't say you can do that, and people who are like, well, it doesn't say you can't. Gotta love people. All right. So in discussing a potential censure or other statement of disapproval directed at the president by the Congress, some have also suggested a fine of the president or requirement for the president to make monetary restitution for the costs of independent counsel investigation since January of 1998. Now again, this is Bill Clinton in particular. Like a censure of the president, there is no express constitutional authority to fine the president or any other individual outside of Congress. However, unlike a censure or other sense of the House or Senate resolution used to express an opinion, a mandatory fine legislated by Congress against a particular individual may run afoul of the Bill of Attainder clause of the Constitution, and in the case of the president may raise concerns under the diminution of salary provision in the Constitution. It is at least theoretically possible that an agreement might be arranged between the President and the Congress for the President to voluntarily accept a congressional statement, suggestion, and or direction concerning particular restitution or other act of contrition, and not to challenge the authority of any such legislative statement or act. In such a case, as a practical matter, regardless of the potentially significant implications for policy or precedent, it may be difficult for anyone other than the individual actually aggrieved or harmed, that is, the president, to possess the requisite legal standing to challenge in court such an arrangement on the basis of an alleged absence of legislative authority or the violation of constitutional precepts. So let's unpack that, because I did do that pretty quick. So a mandatory fine may run afoul of this bill of attainder. Those of you who are more legal experts, feel free to put in the comments what the heck that is, because I don't have time to look it up right now. And it talks about like reducing your salary provision in the Constitution, and like you could accept it, but in the case of some of our more recent presidents, I don't know if like that would even make a difference unless you ask them to like pay back stuff. I don't know. I could see an argument of being like, you'd have to pay back the January 6th stuff. And it's like, I didn't exactly directly start that. Yeah. Opinion on that last one. So not to challenge the authorities. So regardless of potentially significant implications, it may be difficult, you know, other than the president to really understand, you know, what's going on. Challenge in court. Oh, so legal standing, excuse me. An individual who's actually harmed by the censure. So the alleged absence of legislative authority. So whether or not the president would challenge the censure or not, which kind of, I can't remember. I've always been told Bill Clinton had the Congress was Republican at the time. So this kind of makes sense on Republican Congress censuring Bill Clinton. I don't know if we would get something similar if we have a, you know, same party situation. Although the way the parties have been going, we may, because there's a lot of people who are like, what, you upstart, you have different thoughts and want to take over the party? What? Got to put you back in line. No, you don't. New politicians are great. Or non-politicians, as the case may be. All right, the issue of the proprietary and the authority of Congress or of either House of Congress to censure or otherwise formally reprimand an executive official, including the president in the form of a simple resolution, has been debated and questioned from time to time in the House and Senate. In early congressional consideration, some members of Congress, in their opposition to resolutions which declared either an opinion of praise or disapproval of the executive, cited the lack of an express constitutional grant of authority for the House or Senate to state an opinion on the conduct or propriety of an executive officer in the form of a formal resolution of censure or disapproval. Others argued that impeachment was the proper and exclusive constitutional response for the Congress to entertain when the conduct of federal civil officers is called into question, rather than a resolution of censure. Concerning judicial officers, precedents indicate the House has on occasion either rejected or not dealt with attempts to consider a censure motion of federal judges offered by the Judiciary Committee as an alternative to articles of impeachment, and parliamentarians have noted an apparent disinclination of the House to consider censure as part of the impeachment procedure. So yeah, basically, historically, it's been like, if you're going to be this mad about someone in the executive branch, you just need to impeach them. Like, don't waste our time just trying to pass resolutions like, oh, we don't agree with this. You're bad. Both the House and Senate have, however, in fact, adopted resolutions or statements in the past expressing their opinion, disapproval, or censure of a government official other than a member of Congress. Such an expression of censure of a federal officer by the House, Senate, or Congress is not an impeachment of that civil officer under Article 1, Section 2, Clause 5, and Section 3, Clause 6 of the Constitution, nor is it a punishment of one of the House's or Senate's own members under Article 1, Section 5, Clause 2. Furthermore, censure would also not, in most cases, be within those inherent or implicit authorities in the nature of contempt typically imputed to democratic legislative assemblies to protect the dignity and integrity of the institution, its members, and proceedings. So yeah, as I often joke, I'm probably someday going to be found conduct inappropriate for a librarian and kicked out of the profession. Just because I speak my mind and happen to differ on some things, among all sorts of other crazy stuff. Anyway, so yeah, generally that's what the whole nature of contempt is. Like, we want our institution to still look good and not reflect your particular mistake. All right. It has, however, become accepted congressional practice to employ a simple resolution of one House of Congress or a concurrent resolution by both houses for certain non-legislative matters, such as to express the opinion or the sense of the Congress or of one House of Congress on a public matter, and a resolution of censure as a concurrent or simple resolution would appear to be in the nature of such a sense of Congress or sense of the House or Senate resolution. The absence of express constitutional language of the Congress or the House or the Senate individually may state its opinion on matters of public import, and resolution of praise or censure is not necessarily indicative of a lack of capacity to do so, or that such a practice is per se unconstitutional. Just because they haven't done doesn't mean they can't. It is recognized in both constitutional law and governmental theory that there are, of course, a number of functions and activities of Congress which are not expressly stated or provided in the Constitution, but which are nonetheless valid as either inherent or implied components of the legislative process or of other express provisions in the Constitution, or are considered to be within the internal authority of democratic legislative institutions and elective deliberative bodies in general. Yeah, back to strict constitutional interpretations. Says I. The practice of the House, Senate, or Congress to express facts or opinion in simple or concurrent resolutions has been recognized since its earliest days as an inherent authority of the Congress and of democratic legislative institutions generally, and the adoption of the sense of House or Senate resolutions is practiced with some frequency in every Congress. A censure of the president, of course, may raise additional issues to and different from those concerning congressional capacity to state opinions in resolutions on other matters. So, do we have precedent for this? Periodically, during the 19th century, Congress debated and considered the censure of a president of the United States. In the instances reviewed, the considerations have been in one House of Congress only, rather than concurrently in both houses. The Senate adopted a resolution in 1834 stating that certain conduct of President Andrew Jackson involving a policy dispute concerning the removal of the Secretary of the Treasury and the question of the availability of certain documents, sound familiar, was in derogation of the Constitution or the laws of the nation. President Jackson issued and sent to the Senate a strong protestation of the censure concerning both the prerogatives of his office and the powers of the Senate to censure. Sound familiar? The president's protest concerning a vote and a proceeding in the Senate was found by the Senate in formal resolutions adopted by the body to be inconsistent with the just authority of the two houses of Congress and a breach of the privileges of the Senate, and was not allowed to be entered on the journal, which is the thing of record that we have that tells us what the Senate's up to. 3 years later, however, upon the president's political allies regaining control of the Senate expunged the original censure resolution. The Senate resolution concerning President Jackson did not expressly contain the word censure or other specific word of condemnation, and some critics of Congress's authority to adopt such resolutions of censure have categorized the 1834 resolution as one other than a censure of the executive. So yeah, nothing ever changes, right? So Andrew Jackson gets censured, he gets, well, he doesn't get kicked out, but then he gets reelected and his party gets the Congress, and then they're like, never mind, we're going to expunge that, we like you. It's not who you know sometimes, or it's not what you know sometimes, it's who you know. Anyway, in 1860, the House of Representatives adopted a resolution stating the president's conduct was deserving of its reproof in a matter concerning the conduct of President Buchanan and his Secretary of the Navy in allowing political considerations and alleged campaign contribution kickbacks to influence the letting of government contracts to political supporters rather than the lowest bidder. Yes, we also had this too. People were so greedy back in the day. After debating both the substance of the charges and the authority of the House to adopt such a resolution, characterized by one member as censuring indiscriminately the President of the United States and the Secretary of the Navy, the House adopted Resolution 10661. It may also be noted, although not a resolution of censure, the House in 1842 adopted a report from the Select Committee to which the President's veto message had been referred, which strongly criticized the actions of President Tyler for gross abuse of constitutional power and bold assumption of powers never vested in him by any law, for having assumed the whole legislative power to himself and levying millions of money upon the people without any authority of law, and for the abusive exercise of the constitutional power of the President to arrest the action of Congress upon measures vital to the welfare of the people. Similar to the instances in the Jackson censure, President Tyler sent a protestation of the House's actions to the House, which then adopted 3 resolutions of similar wording and import as the Senate's resolutions in the Jackson case, saying the President's protest would not be accepted and was in derogation of the rights and privileges of the House. So, yeah, President Tyler. I should learn more about President Tyler. I forgot how he got into this whole exciting mix-up. But yeah. Bribing people, accepting bribes, all sorts of fun times. All right, other resolutions of disapproval or censure of a president have been debated on the floor of the House or Senate. The House debated the issue of a resolution criticizing President John Adams in 1800 because of a communication from the president to a judge, which the president's critics deemed to be a dangerous interference of the executive with judicial decisions concerning a celebrated deportation case. A resolution, which originally would have congratulated General Zachary Taylor for his conduct in the Mexican War, was amended in a procedural motion on the House floor to refer to the resolution to the Committee on Military Affairs to include as an amendment to an amendment of the referral a disapprobation of President Polk's waging of an unnecessarily and unconstitutionally begun war. So yeah, we're glad that you did your service really well, but we also want to add this addendum that was a bad war. Okay, or started wrong. Again, we had this happening long before Vietnam. Though the amendment to the referral was adopted, research has not indicated that the underlying resolution was ever passed by the House after referral to the committee. The Senate in 1862 also debated and tabled a motion for censure of James Buchanan, who had recently been President of the United States, for alleged failures while President to take the necessary action to prevent the cessation from the Union of the several Southern states. More recently, a censure resolution concerning President Richard Nixon was introduced into the House in 1974, but received no floor consideration, which is French for nobody went and talked about it. Just, someone threw it in and everyone's like, no. He's good, and Nixon fortunately caught on that for his legacy it was just better leaving quickly. All right. House or Senate also has, from time to time, censured or expressed its disapprobation of other executive officers or of their conduct in the form of a resolution adopted by the body. The earliest attempt found thus far concerned a series of resolutions proposing the censure and disapproval of Secretary Alexander Hamilton, 1793, the texts of which were considered by historians to have been drafted by Thomas Jefferson for introduction by Representative William Branch Giles of Virginia. Some congressional resolutions over the years have merely found misconduct on the part of an executive officer and urged the president to seek the officer's resignation without expressing a specific term of censure or condemnation. For example, after having conducted investigations into the conduct of the administration of the New York Custom House by Mr. Henry Smith, and finding that there was not sufficient time prior to adjournment to finish the matter, the House expressed in a resolution Henry A. Smith's unfitness to hold the office and recommended that he should be removed from the office of collector. Similarly, the Senate in 1924, during the Teapot Dome investigation, passed a resolution indicating its sense of the president immediately request the resignation of the Secretary of Navy. The Senate adopted a resolution in 1886 in which it expressed its condemnation of President Cleveland's Attorney General A.H. Garland concerning his refusal to provide certain records and papers to the Senate about removal from office of a district attorney by the president. In 1896, the House adopted a resolution where it found that the United States ambassador, by his speech and conduct, has committed offense against diplomatic propriety and abuse of the privileges of his exalted position, and therefore, as the immediate representatives of the American people and in their names, we condemn and censure the said utterances of Thomas F. Baird. All right, exciting stuff. Finding, all right, where the rubber hits the road. Don't worry, we are already over the halfway point. And a lot of it is citations, as you can see. As a general proposition, it may be stated there is no authority for the Congress or either half of Congress to levy a mandatory fine against an individual or to otherwise punish an individual person absent some recognized legislative powers such as the express constitutional authority in Article 1, Section 5, Clause 2 of the Constitution, allowing either House or Congress to punish one of its own members. The noted parliamentary and legislative authority Luther Stearns Cushing, in discussing the general and traditional powers of legislative institutions in the United States, explained in his 1856 treatise, in England, both houses of parliaments were anciently in the practice of imposing the payment of a fine by way of punishment, and this is understood at the present day to be in the practice of the Lords, but the Commons have appeared to long since waived or abandoned this form of punishment, and it has even been laid down that they now have no such power. In this country, with one or two exceptions in which there is a special constitutional provision to that effect, the legislative assemblies are not authorized to impose a fine by way of punishment. In addition to the general absence of authority and practice of a legislative institution in the United States to fine persons who are not members of that legislature, the levying of fine or other such punishments, such as loss or pay, pension, other remuneration, or benefits, may directly implicate the Bill of Attainder clause of the Constitution as discussed below. All right, we're finally getting to the Bill of Attainder. So maybe you don't have to put comments. Tell me what it is. Hopefully my coworker won't come back because, yeah, we're about 25 minutes. No specific penalty or punishment necessarily follows the adoption of a resolution which merely expresses a censure or states another term of disapproval or condemnation of an individual other than the statement itself and the potential collateral or incidental political damage that might be incurred as a result of Congress's expression of its opinion. Okay. Furthermore, is questionable under the Bill of Attainder clause of the Constitution, Article 1, Section 9, Clause 3, whether Congress may in any event inflict a mandatory penalty or punishment upon the President or upon any other specified executive official by means of a legislative act other than through impeachment. The provision of the Constitution forbidding Congress from adopting bills of attainder is directed at what are generally described as legislative punishments. It may be instructive to note that in discussing the impeachment provisions of the Constitution at the Convention of 1787, George Mason had recommended expanding the grounds for impeachment beyond merely treason and bribery to maladministration, indicating that without broadening the grounds for impeachment, the Bill of Attainder Clause of the Constitution might otherwise bar Congress from dealing with the many general and dangerous offenses which do not rise to or constitute bribery or treason. Yeah, I could see that. It's also up there with like my constant complaint about like removing property and replacing it with pursuit of happiness, where I'm just like, property just makes so much more sense. Yes, I know it's all about landed white guys, but eventually everyone else got property too. And yeah, we should have just left that in there. It's a lot easier to define property than pursuit of happiness. Anyway, under the Bill of Attainder Clause, the Congress may not generally levy a legislative punishment, such as a mandatory fine, upon a specified individual who is not a member of Congress, nor adopt a punitive measure, for example, in the form of a legislative prohibition on the payment of salaries to certain specified officials in the government. So theoretically, they can't stop paying the president either, even if they do censure him. There may be some argument that a public rebuke such as censure, because of the potential for damage to one's reputation and possible political or other public aspirations, may in itself constitute a punishment by the Congress, and thus, since not expressly authorized, would fall within those legislative punishments prohibited by Bill of Attainder Clause. It may be argued that the intent of such a censure would appear to be clearly punitive and not remedial. However, it does not appear that a censure adopted in its traditional form as a simple or even concurrent resolution with no binding effect and stating only an opinion qualifies as a bill of attainder, since it is not in the constitutional and congressional context a bill, as it does not become law, nor is a measure that has the force or effect of law. So just to summarize that, yeah, in theory, if you're a politician, you're rerunning, just doing the censure may constitute a punishment, in which case it falls under this Bill of Attainder, in which you can't punish people. However, if you're doing it as like a simple or concurrent resolution, concurrent just meaning both houses, and it's essentially just stating an opinion, it is, well, it doesn't actually qualify as what they call a Bill of Attainder because it's not a bill, it's not a piece of legislative documentation that's intended to become law. So that's what a bill is. It's going to become a law or not become a law. And because a censure is not a bill, it is not part of this Bill of Attainder. It's just them saying, you stink and we don't like you. Reminds me a lot of our union when we vote, like, what do you call it? Vote of, no, I want to say vote of no contest, but that's not it. But yeah, we don't like the person in charge, so we're going to do this whole vote, which doesn't really do anything other than say all the faculty don't like you. Anyway, a censure, which would take a less traditional form than a simple or concurrent resolution and would be included, for example, in a joint resolution presented to the president, would, however, clearly be a bill, since it is a vehicle which would become public law. Okay, so yeah, if it's more complicated than the simple or concurrent resolution that just states an opinion, then, and if it goes up to the president or it's attached to another piece of legislation, then obviously it's a bill. So you'd have to do it kind of by itself. I'm kind of a fan of that. Like, I hate this whole compound legislation where you have to pass it to know what's in it. That's malarkey in my opinion. Anyway, as such, it would raise the legal and constitutional issue of whether a formal or public expression of opinion and disapproval by the legislature in that law directed at a specific individual is a legislative punishment contemplated by the Bill of Attainder provision. The Supreme Court has explained in Nixon versus Administrator of General Services that there are 3 tests for determining whether a law directed at a specific individual is a prohibited legislative punishment: the historical test, the functional test, and the motivational test. The historical test looks to determine if the punishment inflicted is one which has been traditionally considered a punishment, as either a bill of attainder or a bill of pains and penalties. As succinctly summarized in a lower federal court, the historically recognized punishments include death sentence, imprisonment, banishment, confiscation of property, and barring individuals and groups from participating in specified employment or vocations. Since the Supreme Court recognized the possibility that new burdens and deprivations may be legislatively fashioned in the future, to further an additional test were provided for any such new burdens and deprivations created by the legislature. The functional test looks to determine if there are non-punitive, regulatory, or remedial legislative processes that are advanced by the new legislature burdens imposed. So, yeah, are you making things worse? The motivational test inquires into whether the legislative record evinces a congressional intent to punish. So, yeah, what's the motivation behind what they're doing in this bill? A mere censure of the president or other executive official in a law enacted by joint resolution would not appear to meet the historical test as specified by the Supreme Court, as is neither a death sentence, imprisonment, banishment, confiscation of property, barring individuals and groups from participating in specified employment or vocations. I know that sometimes they have tried to bar people from rerunning for office, so that would fall under that with Bill of Attainder, I believe. Although the function and motivation for a censure might in fact be able to be convincingly argued to be punitive in nature, it is clear from the Supreme Court's explanation that the act of the legislature must, as a threshold matter, place some sort of burden or deprivation upon the subject of the legislation. So there is an issue as to whether an expression of censure or condemnation in a law is in itself and without further disabilities or penalties a burden or deprivation in fact or in law upon the subject of the censure. So it's kind of like defamation. Is it actually going to have an impact on you or not? As seen by the foregoing analysis and discussion, enacting a censure in a non-traditional and unprecedented format of a bill, such as a joint resolution, would provide at the very least an opportunity for a congressional argument of Bill of Attainder, constitutional, not congressional, excuse me, a Bill of Attainder that would not exist if a censure was adopted in a non-bill vehicle that is a simple or concurrent sense of resolution. So this sounds like the person writing this is essentially making an argument to Congress, like, if you want to impeach Slick Willie, you guys have to do it as like one simple, one basic thing. Don't attach it to anything else. Don't make it punish. Just be like, this is not okay. We do not condone our president doing this. As to fines and bills of attainder and ex post facto laws, it may be noted that in some instances, the courts have found that certain civil fines and forfeitures were remedial measures and not punitive, so as not to violate the ex post facto provision or the excessive fines clause. It may be possible under this analysis to argue that certain fines, required restitutions of funds to the government, may also not be punitive under the Bill of Attainder clause as long as they merely reimburse the government for investigative and prosecutorial costs. So yeah, unfortunately, if you were making the January 6th argument, then it wouldn't work for this because, yeah, it's not investigative or prosecutorial. You just need to restore things to the way they were because some people tore up some stuff. Any argument of this nature at the instance at hand, however, would face the seemingly difficult task of overcoming the motivational test, considering the express statements by individual members concerning the appropriate punishment in this particular case, as well as the inference that a mandatory fine and requested restitution that accompanies or is coupled with an express censure or other explicit statement of disapproval directed at one specified individual would appear in that context be indicative of a punitive legislative intent rather than merely a remedial one. So remedial is like an attempt to fix things and makes things all right. Punitive is an attempt to punish you so you don't do things again. So yeah, the inference and mandatory fine as coupled with it would appear, you know, again. So if it's punitive, it fails that Bill of Attainder. All right, keep going. It would appear to be within the realm of possibility, although without apparent precedent, that the president might voluntarily agree not to challenge the authority and constitutionality of a particular legislative action or statement, and might voluntarily agree to pay a suggested monetary amount as a fine or restitution, along with a censure, to accept some other form of contrition or expiation suggested by Congress or in a sense of Congress resolution. If the payment of restitution or a fine is merely incorporated into a legislative vehicle, such as a simple or concurrent resolution, which is merely a statement of opinion or a sense of the Congress, and which therefore is not binding and does not have force or effect of law, it may be argued, as discussed above, that such a legislative measure would not be a bill of attainder, so it is not a bill, a law, nor is it mandatory or enforceable. In any event, even if the president agrees to abide by the suggestion or opinion, or even if such formulation were incorporated into a mandatory fine or other legislative vehicle with the force and effect of law with the president's agreement, which is, yeah, good luck with that. The question could still ultimately be raised as to who, if anyone, would have legal standing to challenge the act as beyond powers and authority of the legislature if the person affected or aggrieved by the act does not challenge it. So if the person, i.e. the president, who they agreed to all this remediation, thinks it's not punitive, does, you know, who can actually have legal standing to challenge it if the person who's being affected doesn't challenge it? So this is not to suggest that the president or any subject of a legislative act has the ability to waive a constitutional incapacity of the legislature to act, but rather it is a practical question to be raised if such a legislative act does in fact take place. Standing to challenge a congressional act in the courts requires showing that the plaintiff has an injury in fact as a result of the challenged action. A member of Congress does not necessarily have any additional standing beyond a member of the public to challenge a legislative act based merely on an arguable intentional injury or loss of political power, unless there is some potential injury to the legislator, such as when the legislator's vote would be completely nullified. And I think I said that too fast to solely process it. So, yeah, so this essentially says President, it does not have the ability to waive the incapacity of the legislature to act, but if we do this, standing to challenge it has to show that the plaintiff has an injury as a result of the challenged action. So, and it essentially goes on to say that members of Congress are basically the same as members of the public if they're going to challenge this, unless they can show some sort of like loss of political power. Or that would, nullify their vote. All right, diminution of salary. Can we give this person a pay cut? It's like, well, he's making too much money. Again, in terms of the current president, it's probably not going to make a difference. It has also been postulated that provision of law which finds and requires monetary restitution from the president might, in effect, be a diminution of the salary of the president in contravention of Article 2, Section 1, Clause 7 of the Constitution. Proponents of this theory cite the cases concerning similar constitutional limitations on the diminution of salary of federal judges during their tenure in office, which have demonstrated that even some indirect lessening of judicial compensation, such as by the imposition of a new tax after judges have taken office, may work to diminish the overall compensation of those federal judges as contemplated by that provision of the Constitution. There is no precedent which makes it clear or provides a definitive ruling as to whether a mandatory fine or required restitution directed at a particular officer would be a diminution of salary under the Constitution. So essentially asking to pay stuff back, is that a diminution of salary or not? It may be noted that the fine or restitution to the government could be paid out of funds other than the president's salary compensation, such as from private contributions or loans. Yeah, makes sense. However, it would be a new financial obligation to the United States government placed by the Congress upon the funds available to the president during his term, and not an application of pre-existing provision, law, or regulation, or merely an increase in current existing financial obligations. So essentially we're making new legislation, and would be a reduction which is applied directly and solely to the president by Congress. So yeah, theoretically he could pay it back. However, that's like a new financial obligation. That's getting Congress involved in some murky stuff. That's kind of how I read that one. All right, separation of powers and policy implications. Critics of a congressional censure of the president or of other executive officials often argue that such congressional action violates the principles of separation of powers within the constitutional framework of separated powers. Many of the arguments forwarded, however, appear in the nature to be policy arguments of why it would or would not be a good policy, practice, or precedent for the House, Senate, or Congress to censure, or for the president to agree to a censure. As important and significant as such policy arguments are, they do not necessarily address the legal or constitutional capacity or incapacity as interpreted by the Supreme Court or of the House or the Senate to adopt such resolutions. Very briefly, those types of congressional actions which the Supreme Court has found to violate the principles of separation of powers within the Constitution have been those which aggrandize the powers of one branch at the expense of the powers of the other, or that independently interfere with or impermissibly undermine the powers of another branch by preventing that branch from carrying out its constitutional duties. So yeah, always trying to balance the executive and the legislative. It's tough. As stated by the Supreme Court, in determining whether the act disrupts the proper balance between the coordinate branches, the proper inquiry focuses on the extent to which it prevents the executive branch from accomplishing its constitutionally assigned functions. This issue may need to be framed as to whether statements of censure in the House or Senate or the Congress concurrently would be found to impermissibly undermine the authority of the president by interfering and preventing the carrying out of the executive's constitutional duties and functions. So yeah, if they censure him and he's still got to keep working, like, does that undermine his authority and his ability to be our chief executive officer? So yeah, that's an interesting one. I can tell I can get to the bottom of my water, but that's okay. Probably done at the end of this page, I think. This page or the next. Legal and constitutional issues and questions of legal standing aside, there are also potentially important policy considerations which the Congress may wish to consider. Implications, not considerations. On the one hand, an agreement or deal with the President of the United States voluntarily accepts the censure vote of the Congress, either through simple or concurrent resolution, or through a joint resolution which the President signs to indicate his acceptance, or a censure plus some other act of contrition, might arguably provide for the inappropriate public consequence to the acts of a president, which, while either found highly offensive or even illegal, might not be considered by Congress to constitute treason, bribery, or other high crimes or misdemeanors, which is kind of the thing with Bill Clinton. I'm like, I don't think that's treason, bribery, or really a high crime. It's not good, but it's not that. might be argued that a censure and or other punishment recommended and agreed to by the president would allow for a formal public statement by the representatives of the American people indicating strong disapproval of such conduct without subjecting the country to as wrenching and disruptive a process as impeachment and an attempt to remove a democratically elected president. If crimes were committed by the president would be subject to criminal indictment and prosecution in the normal judicial process after leaving office, which is kind of what happened with Trump. So, yeah, be careful, Trump. Be careful, Trump. So, yeah. Better than impeachment, but we haven't been doing this in a long time. We seem to go straight to impeachment these days. And like I said, I think Clinton was like the watershed for all this. However, on the other hand, it might be argued that an action of this nature, even merely a censure of a president, is an extra-constitutional measure not contemplated by the express provisions or design of the Constitution. The sole method in the Constitution for dealing with serious executive wrongdoing is the impeachment provision. As to legislative punishments outside of impeachments, it may be noted that the Bill of Attainder Clause was an intentional limitation on congressional powers to punish specified individuals based on due process and separation of powers concerns. Additionally, the diminution of salary provision was adopted within the Constitution's separation of powers framework and among its checks and balances to ensure the independence of the executive from the Congress. It has also been argued that even if not technically a bill of attainder nor a diminution of salary, and or even if unchallenged by the subject of the fine or similar congressional punishment, such action may establish a precedent for future actions, threats of large monetary fines, or agreements into which a president may be pressured by the specter of impeachment proceedings, which could tend to interfere with or upset, to some degree, the balance contemplated in the Constitution in the relationship between the executive and Congress. So, in conclusion, you can do this, but it might not be a good idea to do this either. You might be better off sticking to impeachment because that's legally what we're provided for. So thanks for spending this 40 minutes with me. This was an interesting document in light of all the fun impeachment threats that have been going on since Bill Clinton.